I'd like to start with you, if that's all right. Commenting on June Medical versus Gee, the Supreme Court's decision in that case, you've said, quote, Louisiana's challenge to third-party standing could have sweeping implications for civil rights, not just abortion, shutting the courthouse door to entire classes of people. What are the limiting principles of third-party standing?
Thank you so much, Senator. The court has laid out a number of principles for third-party standing. One of the major ones that was at issue in that case is whether the law directly impacts the plaintiff in the case. So in order to assert third-party standing on behalf of others, the plaintiff also has to be directly regulated by the law.
So what are the sweeping implications that June Medical would have for that, or that Louisiana's position in that could have?
Yes, Senator, I was referring to other circumstances where, for instance, other medical professionals have brought claims on behalf of their patients, not even concerning reproductive health care, but just other types of health care and what it could mean for those types of cases.
To what other civil rights were you referring when you made that statement?
I was speaking, for instance, about contraception, Senator, and
what part of the June Medical case or the arguments raised in it would have sweeping implications for contraception?
Cases defending the right to contraception, Senator, have also been brought by medical professionals. So if those medical professionals didn't have third-party standing to assert the rights of their patients, it would have impacted those cases as well. That's what I meant.
Reacting to the Supreme Court's decision in Dobbs, you helped draft a report, a report that carried the title, The Constitutional Right to Reproductive Autonomy, Realizing the Promise of the 14th Amendment. Now, the report characterized the Supreme Court's recent Dobbs decision as, quote-unquote, callous, one which would, according to the report, quote, relegate women to second-class status, representing, according to the report, quote, a cataclysmic retrogression of rights in the United States. And it goes so far as to call the Dobbs decision from the Supreme Court an egregiously wrong one, and admonishes this period. It says that this is no time to turn away from the courts. It is a critical moment to insist courts fulfill their roles in ensuring equal justice for all, close quote. What is it that you think that the courts need to do in order to rectify what you believe was an egregious error in Dobbs?
Senator, I contributed to that report with a number of my colleagues, and obviously I'm not an expert in every single sentence of the report. I think the report was simply reiterating the view of my organization as an advocacy organization that we had argued to the court that the Supreme Court should have retained the previous precedent of 50 years and that many people in the country had relied on that precedent for several generations.
You also said that the impact of Dobbs will be, quote, swift and severe. And you insisted, quote, we're on the verge of what may be the biggest public health crisis we have ever seen in decades, close quote. In a world in which more babies are being born and born alive instead of being aborted, would you call that a public health crisis? Not just any public health crisis, but the biggest public health crisis that we've seen in decades, worse than COVID-19? Or what about HIV/AIDS? Help me understand that.
Senator, absolutely. In that report, which again was an advocacy report on behalf of the organization, we were talking about the implications of forcing women to give birth against their will, not about the implications for women who want to have a child. So the report is simply discussing...
Right, no, I understand that, but you did say it's the biggest public health crisis in decades, did you not?
Yes, Senator, what the report was referring to there, I believe, was the fact that the maternal mortality rate is so much higher for women who are forced to continue a pregnancy. It's 14 times higher, and the maternal mortality rate has significant disparities, so it would have serious public health implications for women who are forced to continue a pregnancy against their will.
But this wasn't an advocacy report. This is your statement, a statement you made to Axios, and you put your name on it when you were under consideration for judicial consideration. So you can't write this one off as something that you did just as a lawyer. This was you.
Senator, I I believe the statement that you're talking about would have been a statement that I made to a reporter in my role as an advocate at the center. And so I was talking about the implications of the Supreme Court's ruling and reiterating arguments I had made to the court.
19 million black babies have been aborted since Roe. And I'm sure the number is much higher 7 years later. That was a statistic that was live as of 2015. 36 to 40% of abortions are performed on black women, even though black Americans make up fewer than 14% of the American population. In New York City, in statistics from several different years, recent years, more black babies have been aborted than born alive. And yet, one could argue that this is a grave threat to the African American population of the United States and to parts of the United States like New York City, where very often more babies are being killed through abortion rather than being born alive. You stand by your statement today that this is the greatest public health crisis, that is the Dobbs decision, that we faced in decades?
Senator, again, I made that statement as an advocate, and as an advocate, I argued for women to be able to make their own personal medical decisions regardless of race.
You can't just throw out baseless claims and call it advocacy.
Thank you, Senator Lee. Senator Blumenthal.
Thanks, Mr.